Hey guys and gals, this is the Bar Exam and Chill podcast. I'm your host TJ, and today we have a MEE question from a UBE exam. This one was administered October 2020. This is the exam right after COVID. Let's jump right into the hypo. On July 1st, a restaurant owner was arrested and charged with arson after a June 1st fire destroyed his failing restaurant. The prosecutor plans to call a bartender to testify at trial. The bartender had worked at the owner's restaurant and is expected to testify as follows. Quote, "The owner fired me at the beginning of May. A few weeks before the fire, on April 23rd, before I was fired, I showed up at the restaurant a little early for my shift. The owner was talking on the phone when I arrived. As I walked in, I heard him say, quote, 'I know it's risky, but I'll do whatever it takes to get back some money from this lousy restaurant.' When I came to the restaurant after I was fired to pick up my final paycheck, I overheard one of the waiters telling the owner, quote, 'Count me in on your plan to burn down the restaurant. I've recently done that sort of thing and I haven't been caught.' End quote. The prosecutor also plans to introduce a written and certified report prepared by a police arson investigator on August 1st. The arson investigator report states, quote, 'The arson investigation report was prepared to assist in determining the cause of the June 1st restaurant fire and in developing evidence relevant to the pending prosecution of the owner for arson. Pursuant to investigation of the interior and exterior of the premises, I have concluded that the fire began inside the restaurant, where I detected the presence of fire accelerants. The possibilities of a naturally occurring or accidental fire, electrical fire, or gas fire have each been eliminated using a range of tests and reconstruction models. Based on my training as an arson investigator, I conclude that the fire did not occur accidentally and that the use of fire accelerants inside the structure caused the fire to spread quickly and increase the extent of the damage. The bartender is available to testify at trial, but the waiter is unavailable because he fled overseas after learning that he was under investigation for arson, and the court cannot compel him to attend the trial or otherwise testify. The arson investigator is unavailable to testify at trial because he died, but the prosecutor plans to introduce the arson investigation report through the testimony of an expert witness, an out-of-state arson investigator who did not participate in the arson investigation. The jurisdiction's rules of evidence are identical to the federal rules of evidence, and the jurisdiction affords criminal defendants no greater rights than those mandated by the federal Constitution. The owner has objected to all the proffered evidence mentioned above on the grounds of hearsay. The owner has also raised a constitutional objection to the introduction of the arson investigation report. Question 1. Should the judge allow the bartender to testify about what he overheard the owner saying on the phone? Explain. 2. Should the judge allow the bartender to testify about what he overheard the waiter saying to the owner? Explain. And 3. Should the judge admit the certified investigation report in light of A, the owner's hearsay objection? Explain. And B, the owner's constitutional objection, assuming that the hearsay objection is overruled? Explain. Let's jump into question 1. So this is about the bartender's testimony about the owner's phone statement. Our issue here is whether the bartender's testimony about the restaurant owner's out-of-court statement on the phone is admissible over a hearsay objection. So our rules, we lay out hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Hearsay is generally inadmissible unless an exclusion or exception applies. So that's your rule statement that you have to have down for evidence. It's going to be on pretty much any evidence question. You just define hearsay and say, hey, you can't bring this in unless an exclusion or an exception applies. And we've got under the federal rules of evidence, a statement is explicitly excluded from the definition of hearsay. It's classified as non-hearsay if it is offered against an opposing party and was made by the party in an individual or representative capacity. This is commonly referred to as the opposing party's statement or a party admission. So because it's non-hearsay, no separate hearsay exception is required, and the declarant's availability is irrelevant to the analysis. All right, so we've got our rules here. Let's apply them to the facts. Here, the declarant is the restaurant owner. That's the defendant. He made the out-of-court statement on April 23rd when he said, quote, "I know it's risky, but I'll do whatever it takes to get back some money from this lousy restaurant." The prosecutor is offering this statement against the owner at his criminal trial for arson. So because the statement was made by the opposing party himself and is being offered by the prosecution against him, it falls squarely into the opposing party statement exclusion. It does not matter whether the owner knew the bartender was listening or whether the statement was an outright confession. It's a statement by the defendant offered by the state. So our conclusion is straightforward and simple. It's yes, the judge should allow the bartender to testify about the owner's phone statement because it is an opposing party statement, making it non-hearsay. So nice and easy. We've got non-hearsay, right? You've got to have in your mind clearly before you get into the bar exam, what are statements that are non-hearsay versus what are statements that are hearsay, where you want to analyze all that long list of exceptions. So outside the context of this hypo, I just want to go through really quickly what are non-hearsay statements. Broadly speaking, we've got three main non-hearsay statements. Non-hearsay is within these three categories generally. This is commonly tested on the MBE as well as the essay section, so it's good to know these. Number one, you've got statements not offered for their truth. These are non-hearsay. So what are statements not offered for their truth, right? Hearsay is an out-of-court statement offered for the truth of the matter asserted. If you're offering a statement that's out of court, but it's not offered for the truth of the matter asserted, then it's not hearsay. It doesn't fall under the hearsay definition. So these are not hearsay at all because they're offered to prove not the truth of the matter asserted, right? Something else. So let's go through these. You've got verbal acts, legally operative words, or words with independent legal significance. These are statements that have legal effect, like, words forming a contract. You got offer and acceptance, gift, defamation, threats, or resignation. These are offered to show the words were spoken, not that they are true. They have independent legal significance. So you might find these on an essay or the MBE. You've also got very commonly tested the effect on the listener. This is not hearsay, right? This is offered to show the statement was made and its impact on the recipient. For example, to prove notice or knowledge, motive, or why someone acted, and it's not offered to prove the actual truth of the statements. And then, under this statements not offered for their truth, we also have circumstantial evidence of declarant's state of mind. This is called the state of mind, non-hearsay. It's offered to show the speaker's knowledge, belief, intent, or emotion, not the truth of the content. Second here, for non-hearsay, we've got prior statements by a testifying witness. So under this one, this is categorized as non-hearsay. You've got some requirements. The declarant must testify at the current trial or hearing and be subject to cross-examination about the prior statement. Then it's not hearsay if it, A, is a prior inconsistent statement, it's inconsistent with current testimony, and was given under penalty of perjury at trial, hearing, proceeding, or deposition. This is when you can use it substantively. You can use it substantively as a prior inconsistent statement. B, you've got prior consistent statements. This is consistent with current testimony and offered to rebut an express or implied charge of recent fabrication, improper influence, or motive. And C, you've got statements of identification. Identifies a person whom the declarant perceived earlier. For instance, this could be like identification in a lineup. So these are your prior statements by a testifying witness. These are non-hearsay. Again, you've got to have this requirement that, they were under penalty of perjury and offered in a prior trial, hearing, proceeding, or deposition, and so on. And third, you've got opposing party statements. This is what we just talked about. These are admissions by a party opponent. If these are offered against the opposing party, they're non-hearsay. Awesome. So our conclusion for number one is simply, look, this is the bartender. He's the defendant. These statements are offered against him. It's not hearsay. Therefore, yes, the judge should allow these in as admissible non-hearsay. Let's look at question 2. The bartender's testimony about the waiter's statement, right, when he was talking on the phone. So our issue here is whether the unavailable waiter's out-of-court statement to the owner is admissible over a hearsay objection. Our rules here are going to be that because the waiter's statement is an out-of-court statement offered for its truth, it is hearsay. So we're going to have to analyze, is there an exception that applies? We've got one exception that we're going to go through. This is statements against interest. So to qualify as a statement against interest, this is an exception to the hearsay requirements. You've got these following requirements for statement against interest. Number one, the declarant must be unavailable to testify. You've got to have these in your mind. Some of these requirements against, exceptions to the hearsay, the declarant actually has to be unavailable, like the dying declaration, statement against interest, former testimony. If you're going to use those, the declarant has to be unavailable. So here, our first requirement, got to be unavailable. Number two, the statement has to be made, and it has to be contrary to the declarant's proprietary or pecuniary interest, or it has to have such a great tendency to expose the declarant to civil or criminal liability that a reasonable person in the declarant's position would have made it only if they believed it to be true. So one, he's got to be unavailable. Two, it's got to be against their proprietary or pecuniary interest such that you wouldn't make that statement unless it was true. And three, in a criminal case, if the statement tends to expose the declarant to criminal liability, it must be supported by corroborating circumstances that clearly indicate its trustworthiness. So if we're going to have a statement against interest, you got to have one, it's unavailable. Two, it's got to be against their interest. And three, if it's a criminal case, you've got to have corroborating circumstances that indicate trustworthiness. Let's apply this to our facts here. First, the waiter's unavailable. That's given to us in the facts, right? He fled overseas. Facts explicitly state that the court cannot compel his attendance, so he's unavailable for purposes of our prong one. Second, the statement to the owner, count me in on your plan to burn down the restaurant. I've recently done that sort of thing and haven't been caught. That strongly subjects him to criminal liability. He's confessing to forming a conspiracy to commit arson and confessing to a prior unpunished arson. So, that confession directly subjects him to criminal liability. A reasonable person would not expose themselves to such severe penal consequences unless the statement was true. And finally, do we have corroborating circumstances that indicate trustworthiness? Well, the restaurant did burn down due to arson, right? So shortly after the conversation took place, the restaurant burned down. That means that the statement is likely trustworthy. So here we would simply conclude that yes, this statement is going to be admissible. The judge should allow the testimony about the waiter's statement because it qualifies as a hearsay exception, namely the statement against interest. Awesome. That's our straightforward analysis for this question. It looks like, you want to try and analyze anything else that might be reasonable, try and get some extra points. There is this other classification of non-hearsay, which is the co-conspirator statement. Under the federal rules of evidence, a statement is not hearsay if it is offered against an opposing party and was made by the party's co-conspirator during and in furtherance of the conspiracy. So if we have a co-conspirator's statement, you've got also some rule elements that we have to satisfy. Let's go through those. Number one, a conspiracy has to exist. Number two, the declarant and the defendant have to be members of that conspiracy. And number three, the statement has to be made during or in furtherance of the conspiracy. So here we do, does a conspiracy exist? Well, it looks like a conspiracy to burn down the restaurant may exist. The declarant and the defendant were members of the conspiracy. He's saying, yes, I want to join. So it looks like we have that. We'd have to analyze this one under this third prong of, was the statement made during and in furtherance of the conspiracy? Those are two tests there. So let's talk about, was it during, I guess? The statement has to be made during the conspiracy. So a conspiracy begins when two or more people agree to commit a crime. When the waiter said, count me in, was he joining an existing conspiracy between the owner and someone else? Or was this the moment of formation of the conspiracy? Obviously, we don't have facts to say that there was some other conspiracy, so we would say, okay, maybe they formed the conspiracy at this statement. If the owner was acting alone until this moment, the statement might be viewed as an offer to conspire rather than a statement made during an active conspiracy. This is kind of a technicality. We might just argue, hey, this is during the conspiracy because it formed it and it was ongoing. This conspiracy to burn down the restaurant was now taking place. So we might have this during the conspiracy requirement. we might run into problems at this in furtherance. So let's talk about it. What's our rule for in furtherance? For a statement to be in furtherance of a conspiracy, it must be intended to advance the objectives of the conspiracy. In our facts, the waiter says, "Count me in on your plan to burn down the restaurant. I've recently done that sort of thing and haven't been caught." This is going to be like an idle chatter problem. Courts will often distinguish between statements that advance a plot, like planning the timing, right? Discussing the accelerant. Hey, I use this kind of gasoline, let's use that. Or recruiting. If it's just idle chatting or bragging, it may not be in furtherance of the conspiracy. So we have kind of a narrative problem here. The second half of the statement, bragging about past crimes where he wasn't caught, that's a narrative of past events. It's not really in furtherance of this conspiracy. So, hey, we're kind of hinging on this. Count me in on your plans to burn down the restaurant. We'd have to argue that this is in furtherance of the conspiracy, but he's not really saying like, hey, let's make plans. This is how we're going to do it. So it may be, this one's a little bit fuzzier, but it's obviously going to be better. The prosecution's going to want to make the argument that this is a co-conspirator statement because as non-hearsay, it's probably better. It's more useful. You don't have to worry about like declarant availability or anything. So the prosecution is going to argue that this is a co-conspirator statement, and the defense is going to argue this was not made in furtherance of the conspiracy. It may not be super clear here, so your conclusion may go either way. You might say, hey, the judge should let this in as a co-conspirator statement, or maybe it's not in furtherance of the conspiracy, therefore it should be deemed inadmissible under the co-conspirator statement. So we've got number 2. Definitely, we're probably going to get in. It seems to line up perfectly with the statement against interest, and then maybe it could also be classified as a co-conspirator statement and non-hearsay. Nice. That's going to be our question 2. Let's look at question 3 here. Question 3 comes in 2 parts. You've got an objection on the grounds of hearsay to the arson report, and B, the constitutional objection. So let's analyze under the hearsay first. Under A, our issue is going to be whether the certified arson investigation report is admissible under the public records or business records exception to the hearsay rule. Our rule here is a police or investigative report is an out-of-court written statement, making it hearsay if offered for the truth of the matter asserted. We've got these 2 separate hearsay exceptions. You got public records and you've got business records. Let's just talk about generally what are the requirements under the business records rule, what are the requirements under the public records rule. So under the business records rule, a record of an act, event, condition, opinion, or diagnosis is admissible if, number 1, the record was made at or near the time by or from information transmitted by someone with knowledge, right? So you have to have this knowledge requirement. It's got to be at or near the time. 2, the record was kept in the course of a regularly conducted activity of a business, organization, occupation, or calling. Number 3, making the record was a regular practice of the activity. And 4, all the conditions are shown by the testimony of the custodian or another qualified witness. So you have this authentication requirement. So 1, made at or near the time. By 2, somebody, in the regular course of business, that they would usually be conducting this logging activity, and it's got to be a regular activity of the business, and it's got to have a custodian that will authenticate it, right? Public records, we've got, generally speaking, here's our rule. A record or statement of a public office is admissible if it sets out 1, the office's activities, 2, a matter observed while under a legal duty to report, 3, in a civil case or act against the government in a criminal case, factual findings from a legally authorized investigation. Now, there's some nuances here that we're going to talk about. In our rule for public, this is an arson investigation connected to a criminal prosecution. So under the public records exception, which allows the admission of records of a public office if they set out a matter observed while under a legal duty, we've got this, if it's in a criminal case, matters observed by law enforcement personnel, or they're excluded from this exception if offered against the defendant. So this is like if there's a police report or a law enforcement personnel. This is really important for the public records exception. You can't use it against a criminal defendant if it's like the police or a law enforcement. Furthermore, the prosecutors cannot use the business records exception as a backdoor to admit law enforcement reports that are barred by the public records exception. So if it's barred by the public records exception, it may be that the business records rule would apply, but they don't want a backdoor that would allow otherwise stuff that you would exclude under the public records. The courts don't want something that would be excluded to get in this backdoor through the business records exception. So this is kind of our rule statements here for this question on the hearsay analysis of the arson report. Let's analyze on our facts. The report was prepared by a police arson investigator. That is very important. It's a police report. That is undeniably law enforcement personnel. So the prosecution is attempting to offer this report against the criminal defendant. The report itself explicitly states that it was prepared to, quote, assist in determining the cause of the June 1st restaurant fire and in developing evidence relevant to the pending prosecution of the owner. So because this is a police report containing matters observed by law enforcement and it's being offered against a criminal defendant in a criminal case, the law enforcement exclusion is going to apply. So we're not going to be able to allow this under the public records exemption, and we're not going to be able to backdoor this in through the business records exemption because there's this policy exclusion. So for 3A, under the hearsay requirement, no, our conclusion is going to be the judge should sustain the hearsay objection and exclude the arson investigation report under the hearsay exception. So let's look at B here. The arson reports under the constitutional objection. Our issue here is, assuming the hearsay objection is overruled, does admitting a forensic investigative report through a surrogate expert who did not participate in the investigation violate the defendant's Sixth Amendment Confrontation Clause rights? Our rule here is the Sixth Amendment's Confrontation Clause guarantees a criminal defendant the right to confront the witness against them. Under the Supreme Court's ruling in this Crawford case, the prosecution cannot introduce testimonial hearsay against a criminal defendant unless, 1, the declarant is unavailable to testify, and 2, the defendant had a prior opportunity to cross-examine the declarant. So that's our rule here for this Sixth Amendment Confrontation Clause. If you're going to introduce it, you got to, 1, have the declarant unavailable, and 2, you had a prior opportunity to cross-examine them. Because you have a right under the Constitution to confront a witness against you in a criminal proceeding. Now, let's talk about testimonial. A statement is testimonial if its primary purpose is to establish or prove past events potentially relevant to later criminal prosecution. We've got the Supreme Court sort of establishing that forensic reports prepared specifically for trial are testimonial. Here we've got this police arson investigation report. So furthermore, the prosecution cannot satisfy the Confrontation Clause by introducing a testimonial forensic report through a surrogate expert witness who did not personally perform or observe the test or sign the certification. So here we had this arson report prepared. The guy died. They're trying to get in, this second expert, but he's a surrogate expert witness, and he did not personally perform or observe the tests. This guy's concluding, hey, there was these accelerants. I've ruled out that it could be gas or electrical or any of these other reasons, and that guy died. Then they're saying, hey, let's get this other expert. So let's apply this to our facts. The arson investigation report is highly testimonial, no doubt about that. Its explicitly stated primary purpose was to develop evidence for the pending criminal prosecution of the owner. The original declarant is deceased. He's dead, so he's unavailable. That meets that first prong, but the defendant never had a prior opportunity to cross-examine him regarding his methods, right? His conclusions. How did he come to the conclusion that there was all these accelerants? How did he rule out these other forms of legitimate fire? We don't know, and they didn't have an opportunity to cross-examine him. So the prosecution is attempting to bypass this by bringing in an out-of-state arson investigator, right? However, this out-of-state guy, the surrogate, he did not participate in the investigation. He did not perform the test to eliminate the other fire causes and did not author the report. So permitting a surrogate to testify to the testimonial statements of the deceased investigator deprives the defendant of his constitutional rights under the Sixth Amendment to cross-examine the actual analyst. So our conclusion here is also going to be no. The judge should sustain the constitutional objection. Admitting the testimonial arson report through a surrogate expert witness violates the defendant's rights under the Confrontation Clause. Awesome. So we've defined everything. We've got our rules. We've gone through it all. Hopefully that's helpful. And I'll see you guys next time. Happy studying.